The thing about trademarks is that they want to be seen. They only really exist as trademarks if consumers can see them in the wild and connect them with your particular goods or services. But what can you do if you want to launch a new trademark, but you don't want the world to know about it until you're ready? What you may need in that case is a stealth trademark. Let's get into it. My name is John Halski. I'm a trademark attorney at Ryan, Swanson, and Cleveland, and this is Candid Remarks. To unpack what a stealth or submarine trademark is and how it works, first we need to talk about priority. In trademark law, priority refers to the earliest date to which a trademark owner can pin their rights in time. All other things being equal, a trademark dispute between two parties can come down to which party has priority over the other. Trademark rights are also jurisdictional in nature, meaning that in the vast majority of cases, the rights have to be established on a country-by-country basis. Each country may have its own trademark laws and standards, but when it comes to priority, they typically fall into two buckets: first to file countries and first to use countries. Most countries fall into the former category, meaning that the applicant who gets to the local trademark office first typically gets the priority to a trademark even if they weren't the first to use that trademark in that country. The US and a few other countries fall into the latter category, first to use, meaning that priority typically goes to whoever was the first to use a trademark, even if they weren't the first to file an application with the USPTO. In fact, in the United States, it's not even necessary to file for registration to claim trademark rights and have priority over another party. It can still be a good idea to seek registration, though, or at least to consider the possibility. One reason to do so is that an application can give you priority over others even if you have not started using the trademark. And that's where a stealth application comes into play. Most countries in the world belong to the Paris Convention, which provides every application filed for the first time anywhere in one treaty country with a 6-month priority claim window in any other treaty country. Now, what does that mean? It means that once you file to register your trademark for the first time in any treaty country, you can file to register the same mark for the same goods or services in any other treaty country with a priority claim back to the original application's filing date. So imagine that you have filed an application in Canada with a priority claim to an application you filed 6 months previously in the United States. Then you find out that someone had filed to register the same trademark in Canada a month or two before you did. If those two Canadian applications are in conflict, the other party might ordinarily prevail based on their earlier filing date. However, because you have a priority claim, your application would have priority based on the US filing date, which was earlier than either of the two Canadian filings. This is a powerful tool to get ahead of an interloper and prevent someone from claiming rights to your trademark in another country. Now, note that I said that your first application could be filed in any Paris Convention country, and the priority claiming application could be filed anywhere else. This means that you, as a US-based applicant, can file to register your trademark in a country like Jamaica or South Africa, even if you don't have an office or any presence whatsoever in that country. An application filed in a jurisdiction like that may have a slow and discreet reporting process. It may escape public notice and may even be difficult to discover through the normal trademark search. And so, if for any reason you wanted to keep your new trademark out of the public eye, perhaps to keep competitors from seeing what you're doing before you're ready to launch, you can buy yourself up to 6 months of stealth trademark rights before you file your application in the United States, where it will be much easier to spot. And as long as the details of your US application match the details of your stealth application, you'll get the benefit of a 6-month head start in terms of priority. As helpful as this can be, you'll want to keep a few things in mind. Your rights in the United States will still depend on confirming actual use in commerce in the United States. There are ways to establish priority in the United States other than filing for trademark registration. And priority is only one element of establishing and enforcing your trademark rights. But if you ever want to establish rights to a new trademark while keeping a low profile at the same time, talk to a trademark attorney about whether the stealth strategy is right for you. This has been Candid Remarks, a video series produced by Ryan, Swanson, and Cleveland, PLLC. Candid Remarks is the trademark of Ryan Swanson. This video is intended for educational purposes only, and nothing in this video is intended as legal advice. For more information on the topics discussed in this video or other trademark issues, visit ryanswansonlaw.com.